Hello, good afternoon, everyone. Good afternoon, and welcome to today's edition to the Law and You. I encourage you guys to share the live. Good afternoon. Good afternoon. Welcome, everyone. Welcome to this afternoon edition to the Law and You. I invite you guys to share the live, share the link, and come on in. I have a guest here today. We'll be discussing trust and estate law this afternoon. For those of you who are interested in information regarding your estate, your asset, and how you would like to preserve those estate and preserve your assets. Thank you so much for joining us, guys. Welcome, welcome, welcome. I do have a guest who is joining us live. He will be joining us live in a few minutes. I'm so happy to be here. Good afternoon. Good afternoon. Continue to share the link, guys. Share the live. Share the link. Thank you and welcome again. Welcome, everyone. I'm waiting for you guys to get online. And we are going live with my colleague today who's joining us. His name is Claremont Chung. Claremont Chung is joining me this afternoon, and we will be discussing trust and estates. Good afternoon, and thank you for joining this program this afternoon. It's a pleasure to be here. I'm your host, Shellon Washington, and I have joining me this afternoon, like I said, my colleague. His name is Claremont Chung. He will be joining us live this afternoon. Before we get into the program, we will take a quick commercial break, and then I will be back live with our program this afternoon, Trust and Estate, with Claremont Chung this afternoon. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100. Welcome back again. Good afternoon again, everyone. And thank you again for joining us this afternoon. We're going to speak about ways that you can protect your assets this afternoon. So if you are here in the United States or in Guyana or wherever you are, and you have acquired a certain amount of assets and you are wondering, how are you going to be able to protect that asset for your generations behind you, your children, your grandchildren, your great-grandchildren? We are here to discuss that with you this afternoon, and will be joining me shortly. I don't know if my colleague is experiencing some sort of technical difficulty, but he will be joining us shortly. We will be discussing trust and estates this afternoon. So I want you guys to hold tight. I think we're having a little bit of technical issues this afternoon, but nothing that we wouldn't be able to rally through. We'll be able to clear up the technical issues so that we can bring you this program and help you understand ways at which you can protect your assets. I will be right back. Just hang there, guys. My guest is having technical difficulties. We'll be right back. And I'm back here this afternoon. We're still waiting on my guest, guys. Just have patience. He will be here. Like I said, we're experiencing a little bit of technical difficulties this afternoon. So I'm not sure what's happening on my guest end, but I think he's going to be here shortly. Let's start. Let's get into the program while we wait for him to show up. We'll be discussing how to protect your assets. So I know one of the big issue among people of Afro descent, people from the Caribbean, we migrate to other countries. In Ghana, it's very simple when it comes to asset protection. There is nothing much available in Ghana when we talk about protecting assets. What usually happens is people have property, they have house, they have land, and what they usually do is they just write a will, or whenever they die, their family go probate the estate and take over that property. We never really truly sit down and discuss what and how are some of the ways for us to protect our assets as a people. And very often there's something that also happens, which I need to discuss. Like we see what happened with Lincoln Lewis. Lincoln Lewis have ancestral lands, which was passed down from generation to generation, but the land left lingering in one party's name, and the title to the property was never changed. So that created an issue once the generations, many generations, the land passed hand without changing the name on the deed or the title to the land. So we have to discuss some of the ways of how we're going to protect our assets as a people. There are multiple ways to protect your assets, but one of the main ways we are concerned about, and which we will discuss right now, is by way of a trust. We do know that in countries like Ghana, they are trust also, but trust is not utilized very often among our community. A lot of times what we choose to do is to write a will, or simply go ahead and just transfer the property into our children or our family's name. And a trust is seldomly considered. So today we want to discuss with you, what are some of the ways in terms of creating a trust? What are the types of trust you can create to protect your asset? And one of the main ways, like I said to you earlier, one of the main things you can do is create a trust. And there are two types of trust we're going to talk about. We're going to talk about the revocable trust and the irrevocable trust. Until I don't know if my guest is joining, because I'm not sure what's going on, but I know he was having technical problems, difficulties earlier. So I don't know if those technicalities continues and therefore it's preventing him from joining the show. So we can discuss trust and estate together with you and help you to understand some of the ways to protect your asset. Good afternoon. And for those of you who are now joining us, I'm your host, Shellon Washington. And thank you all for joining me this afternoon on today's edition of The Law and You. And like I said, today we're discussing trust and estate. And this is why I wanted my colleague who is experiencing technical difficulties to join me as we discuss trust and estates this afternoon. Trust and estates. So I'm not sure what's going on his end, but hopefully he will still be able to join us. Anyway, so let's get into the issue of the two types of trust we'll be discussing. There's one that is called a revocable living trust, and the other is called an irrevocable living trust. Now, in the sense of a trust, when you think about a trust, it's a way to protect something. And what is always put to a trust is called a trustee. In order to create a trust, there must be a settlor, the person who wants to create the trust and to put assets into it. And then there's a trustee, the person who's going to hold the assets on behalf of the settlor. And then there's the beneficiary, the people who are going to benefit from that trust. Now, usually the settlor is oftentimes, he can appoint himself as a trustee also and the beneficiary, or he can just put those assets there for a particular group of people, which would be his beneficiaries, like his children, his spouse, his family members, whoever he might choose, and he would like to inherit from him. So in this instance, we're going to talk about the revocable living trust. It's called revocable because it means you can revoke it at any time. You could cancel, you can terminate it. Whatever you choose to do, you can do it at any particular time as long as you're alive. And one thing you need to know about a revocable living trust is as long as the settlor is alive, that trust could be terminated. He can choose to do anything he would like to do at any time before he dies. Irrevocable living trust. Now, the irrevocable living trust is a little bit complex, and it could be very simple also, depending on what type of assets you would like to put into that trust. There are different types of assets you can choose to put in there. You can put property, you can put money, you can put house. You know, there's different types of assets you can choose. You could choose to put your investments there. Whatever it is, whatever type of asset you have, you can choose to put it into a irrevocable living trust. Whatever type of asset you think about it, you name it, it can be placed into your trust. And the trust is one of the ways to eliminate the need for a will. The will comes into play when there's no set way of how your assets is going to be distributed once you die. So you would need a will if you don't have a trust. The will tells the beneficiary or the people who survives you what happens to your asset once you die. So once you die now, whatever is left behind, it passes under the will. But your beneficiaries would have to go to the probate court, whether it be in the United States or in Ghana. And I think most countries that follow the common law system has the same thing, where you will need to probate that estate. Now, in this country, if you use a will, you will end up spending money because a lot of times the beneficiaries are clueless as to how and when they're going to go about settling their assets, in terms of, how to probate the estate, what type of forms you need to fill out, which court do you go to. And the court that you usually go to is the surrogate court here in the United States. In Guyana, you go to the high court. The high court is where you probate estates. So in the United States, we have the surrogate court. In New York, that's where we go once the testator or the testatrix dies. Now, you can eliminate all of that, where your beneficiary needs to go probate a will, and they need to take all these different steps to ensure that this is done, by creating a trust. If you go and do the first instance where we're speaking about the revocable living trust, you create a trust, then there's no need to create a will. The trust is adequately going to protect your assets, and it's going to do something else. Once you die, there's no need for anybody to probate an estate, because at that point, the estate is going to fall directly into the trustee's hands. And again, like I said, the fact is, you can limit the trust. You can put clause in there to limit what the trustee is allowed to do, or you can make yourself the trustee, and then you have a successor trustee. Your successor trustee is the person who takes over once anything happens. So you can make yourself as the settler of the trust. You can also appoint yourself as trustee and a beneficiary under your own trust. And then once something happens to you, the successor trustee takes over, and whoever you name in that trust to be your beneficiaries, they would be the parties to benefit from whatever you have put in that trust. And like I said, you can choose to do anything you want to do with your trust. You can put any type of assets. If you have jewelry, you want to pass it under your trust for the benefit of your children, you can put those. You want to pass real estate, you put real estate in the trust. This real estate only creates an additional step, however. In terms of the real estate, if you want to put real estate in trust, you must also transfer that real estate over to the trustee. And the trustee is going to hold that real estate for you as trustee. Now, some people are afraid of trust to some extent, because there's an extra layer that you might need to create with the trust. You have to put provisions in the trust to protect you while you're alive, because if you choose to use a trustee other than yourself, you do not want that trustee to go and sell your asset while you're alive, because the trustee does have very wide powers under the trust. The trustee has the power to invest, to sell, to dispose of. You can limit those powers by carving out the trust in a limited manner, so that the trustee, during your lifetime, the trustee can only manage, maybe collect rents for the property, repair the property if it needs repairing, pay the mortgage, pay the taxes on the property, and this type of stuff. Now, if you choose like I said, if you choose the revocable living trust, your life is going to be a little bit easier. You're going to be at peace, because you can revoke it at any time during your lifetime. It only becomes irrevocable once you die. And once you die, your trustee take over at that point, and your trustee determine what next should be done. Your trustee determine based on the trust instrument whether or not that trustee should sell the property or continue to manage it for the benefit of your beneficiaries. In the instance of where there's a property, let's use a real property. You put the real property as part of the assets under the trust, and the trustee has that property in his name. What the trustee can do is collect the rents, continue to collect the rents. If there's a mortgage, continue to pay the mortgage. If there's no mortgage, continue to pay the property taxes, upkeep the property, ensure the utilities are paid, and manage it in that way. And whatever excess money is left over, the trustee is bound to take that money and distribute it in accordance with the trust instrument. For instance, if the trust instrument says that it is for the benefit of, let's say you have 3 children, 4 children, how many children you have, then that money is going to be split and divided, and your children are going to benefit. If you have 2 children or 3 children and you want it to be divided into a third each, that's how it's going to be divided. If you have 1 child, then you could stipulate that 1 child is going to be paid. If you choose an independent trustee, a trustee like a bank or a family member that you are not benefiting under the trust, then that trustee could be entitled to reasonable compensation. So the compensation the trustee is going to get under the trust is not nearly going to compare to the cost you would have to pay if you have to prepare a will. If you have to get a will prepared and then probate it after you're gone, that your relatives, whoever are going to be benefiting from your estate, will be forced now to go and incur a lot of costs in terms of paying an attorney. Some attorneys take payment up front, and a lot of times, I've said this before on this program, a lot of times your relatives do not have the money to go and afford to pay an attorney to probate the estate. And sometimes they try to do it pro se, and they make a mess of the situation because they're just not familiar with the steps that they need to take in order to have your estate probated. If it's a very simple, small estate, yeah, you might be able to get away with probating it and not incur too much cost by doing it yourself pro se. But if it's an estate that has a lot of assets, let's say 3, 4, 5 properties, and they have bank accounts, there's money, there's a lot of other stuff that's available, then that kind of makes it complicated, and then it becomes an issue for your beneficiaries to be able to do that on their own. The other trust that we want to talk about is the irrevocable one. We've talked about the revocable one, but then there's the irrevocable one, the one that cannot be revoked. Once you write it, it's written in stone. You cannot revoke it at any time during your lifetime. You just have to allow that trust to stay there. And then whenever you die, whatever happens to it, it's irrevocable. Now, if you have an irrevocable trust, even though it says it's irrevocable, of course it could be canceled, because if your beneficiaries or other people doesn't even know it exists, of course you could go to the attorney's office and say, I'd like to terminate, destroy this trust. But it's irrevocable. And a lot of times the irrevocable trust is done when there's mutual estate. So like say there's a husband and there's a wife. They do an irrevocable trust. The reason why, they don't want to do a trust together, and when the first person to die, the one who survives goes and revokes that trust. So it's irrevocable because most times you must have 2 people, or a husband and a wife, or 2 family members would create a single trust together. That trust is irrevocable. No one can break that trust or cancel it or ask that it be revoked, because it's joint assets. Joint things goes into that, is entrusted to the trustee. Therefore, when the first to die is gone, nothing could be done to that trust. It has to remain the same. You cannot revoke your irrevocable trust. And you have to be very sure that this is what you want in order to do that type of trust. Because like I said, most of the times it's joint assets. A husband and a wife would do that. Or 2 parties who are like, maybe you have a business transaction together. Most times relatives engage in an irrevocable trust, or it could be, like I said, a business transaction, business partnership, because the trust is exactly what it says. It creates a relationship whereby assets are vested in one person for the benefit of a group of people or one person. So in that instance, you would like to think about that carefully before you decide, okay, hey, I'm going to go create an irrevocable living trust. And it's called a living trust because it has to be done during the settler's lifetime. So during your lifetime is when you take steps to say, well, okay, I'm going to go create a trust and I'm going to put all of my assets in there so that the assets will never, ever have to go through probate. It will never have to change hands. None of those things you would have to do because you turned it into an irrevocable living trust. So that's what it's called, irrevocable living trust. And the trustee is the position you choose. Whoever you choose to be a trustee, you must choose somebody who is reliable and you can trust that person and know for sure that that person is not going to go and do something that you didn't authorize. And this is why I said you need to limit the scope of your trustee under your trust. Be careful who you choose to be the trustee and ensure that you limit the scope of what that person can do under that trust. Because if you choose the wrong person, then there's a big problem. That person could end up trying to do things without your authorization. But if you limit the trust, limit their ability to do things, limit the scope of it by saying that if the trustee would like to sell property, dispose of it, encumber it, meaning take a mortgage or anything like that, they must get your express written consent or the express written consent of all the beneficiaries under your trust. So there's ways to limit their ability to do anything, act outside of your of the realms of what you really would like to see happening. In the case of a will, you have no control. Once you write that will and you tell the people what to do and how to do it, you have no control, obviously, because you would not be here. The will only goes into effect once the person is dead. On the other hand, the trust goes into effect as soon as you create the trust. As soon as it's created, the purpose of it goes into effect. So you would like to think about a trust as a way to save yourself a whole lot of money, because you're going to save yourself a whole lot of steps, because the trust can have successor trustee. So now literally each time a trustee passes, the asset could just change hands to whoever becomes the successor trustee. And the trustee who is appointed could appoint another trustee, a successor trustee, and so on. So the trust could be in perpetuity. Now, you need to know in Guyana, we don't have, the rules of perpetuity prevents you from having a perpetual trust. Like in America, in the United States, those rules doesn't bound the trust. So you see that there's some trust in this country that will last for generation to generation to generation. That's because the rule of perpetuity doesn't bound you in the United States, but it does create that boundary in Guyana. That's the distinction with the trust in Guyana versus a trust in the United States. We don't have that operation. So you can make it for the benefit of even beneficiaries who are unborn at the time the trust was created, so that the trust will operate in perpetuity from hand down from one generation to the next generation to the next generation, and it will keep going on and on and on forever. All right, guys, so that's the distinction, and you would want to consider carefully when you're planning how to protect your estate and how to ensure that you have your wealth passed down from generation to generation to generation. As you know, guys, we have had that issue where our assets, we have had the problem where we had to start from scratch. Our ancestors were not able to give us assets because it was taken from them. But now you have that ability to ensure that you pass your assets down to generations to come. Your assets could be preserved. So whatever you're working hard for now, whatever you're acquiring now, generations upon generations can enjoy whatever you've acquired, whatever you've worked for. You can ensure that your generations after you are able to sit and enjoy life and utilize all of your hard labor without losing it to inexpensive legal fees, or having to people to just step in and try to show them how to handle things and really end up taking from them. These are some of the ways a trust is a really great way to preserve and protect family assets. And like I said, this is one of the methods the very wealthy people use. They use trust to ensure that their generations that follows them enjoy the assets that they've left behind. Of course, there's other types of trust which we will not be discussing here today because the time is so limited. It's just half an hour, and I saw my text, my guest text and said he was having technical difficulties and he's tried multiple times. I'm not sure what's happening today, guys, but it seems like there's some sort of technical issue. I don't know. I'm not too sure, but he couldn't, for some reason, join us today. But however, I'm going to make sure we try to see if he can join us another time so we can continue the discussion, because my guest, whose name is Clement Tong, he also practices trust and estate, and he will be able to provide more information in addition to what I've given you to help you, to assist you guys in continuing to have a healthy, wealthy family as you pass your assets down from generations to come, and you ensure that your wealth is distributed to your family the way you intend for it. You don't want to have a situation where you die and your assets was never protected and then your family are fighting over it. I've seen this often where people fail to make provisions with their asset. They die sudden, or even if they didn't die sudden, they die a normal death, but they did not make provisions to protect their assets. And guys, don't believe that because you have a trust or anything of that to protect your asset that you're planning for your death. That's not what it is. It's just that you're ensuring that your family members are adequately protected. And just one caution, just so you know, the trust is a little bit expensive, but even though it's a little bit expensive, it's better. You save more up in the long run. You're going to save a whole lot more money in the long run if you can create your trust, put all of your assets, and forget the will. Because if you wait on the will, I'm telling you, that's going to create an issue, and you could end up having family problems, especially if you forgot to even write the will or even create a trust. I see somebody's asking about the foreign trust and the Guyana trust. Like I said earlier, there's a distinction between the two trusts, but either way, both trusts requires the trust instrument should be created upfront. And after you create the trust instrument, then is when you transfer the assets to the trustee. Like I said to you earlier, a lot of people do not utilize the trust instrument in Guyana. I think one of the reasons is it's not as effective as it is. We utilize it way more often in the United States because people have recognized the value of it in terms of preserving and protecting their assets. And another thing, while you would want to do that if you're a person with a lot of assets, even if you're sued, your assets is not in your name. It's not within your power. It's already transferred to somewhere else. So no one can even sue you for your assets. You don't own it. But if everything remains in your name and you're the sole owner and your name is there and you're sued, guess what? You can, if you're sued, you don't have the protection of a corporation. If a corporation is sued, it's limited to some extent. Whatever is in the corporation, that's all the person will get. And you could literally transfer out the assets, dispose of the assets from a corporation pretty quickly. But if you as an individual are sued, you are toasted because now everything is in your name and the person is coming after you for everything that you got. So you can protect yourself. You can protect yourself by creating the trust, create beneficiaries, have your beneficiaries named in your trust as your beneficiaries, remove yourself from the equation. You could put one of your children, two of your children, or two people at a time can serve as trustee. If you don't trust that people are going to deal with you the proper way, you can do it in a way that you have two trustees instead of one. So you know for sure that, hey, I'm protecting myself, I'm keeping myself safe, I'm keeping my assets safe, because no one party would have the exclusive power to deal with all of my assets. I have multiple trustees, at least two trustees managing my assets, taking care of the assets, and none of the assets are in my name. So if you're a businessman, a businesswoman, and you're thinking, oh, I need to protect my assets, I need not have all of this sitting around in my name, that is the perfect way to protect your assets. And it's always good if you're a businessman or businesswoman in the United States to create a corporation for your business and not operate your business in your own personal way. Remember, people, a corporation has limited liability, meaning the liability is only on the face. so they can't pierce the corporate veil except in limited circumstances. They can look behind the corporate document to see who owns the corporation and go into the assets of those persons. But that is an extremely rare situation. This is why you see a lot of times when corporations are sued in the United States, they quickly go and file for Chapter 11. They file bankruptcy. So then they stop you from being able to recover or recoup anything against them. So again, guys, I am encourage you, ensure you protect your assets so that your generations to come behind you will enjoy the benefits of your hard labor without having to worry when you go, what's going to happen? How are they going to share your assets? And the rule, you don't have to, they don't have to worry about intestacy, because if you die without the will, but you have a trust, you're safe. Your beneficiaries are safe and your assets are protected. Guys, I want to say thank you so much for joining me this afternoon on The Law and You as we discussed trust, the two types of trust, revocable living and irrevocable living trust today. Thank you so much for joining me. It has been my pleasure being here, even though my guest had technical problems and he was unable to attend. Thank you so much, you guys. I enjoyed being here and educating you. Like I said, this program is to educate you on your legal rights or ways to protect you legally. Thank you again for joining us. I was your host for this program, Shellon Washington, The Law and You. I will see you again next Saturday. Next Saturday, guys, at 4 p.m. Thank you, guys. I think Wayne is up next with Over to You at 4:30 p.m. At 5 o'clock. I'm sorry, 5 p.m. Thank you, guys. Have a good evening.